Hello students, welcome to AKS. As part of our discussion on Indian polity, we will try to discuss about the directive principles of state policy mentioned in part 4 of the Constitution from this lecture. So, which part of the Constitution are these directive principles of state policy mentioned? They are mentioned in part 4 of the Constitution. They are mentioned in part 4 of the Constitution. And what are the articles which deal with the directive principles of state policy? From Article 36 to Article 51, you have the various provisions dealing with the directive principles of state policy. So, having understood this basic information, we have to primarily remember that the directive principles of state policy are inspired from Irish Constitution, that is the country of Ireland. The Government of India Act 1935 the Government of India Act 1935 had a chapter called Instruments of Instruction to the governors of British provinces. The directive principles have been borrowed from the Instruments of Instruction. So Article 36 states that, gives the definition of the state. When we dealt with fundamental rights, it was Article 12 which defined what is the state. In the same way, here Article 36 defines the state. So that state is the implementing agency of directive principles of state policy. So whatever you have read in Article 12 of the fundamental rights, it is the same thing. Over here, Article 36 and Article 12 are almost the same. They deal with the definition of the state, which are the various executive organs that are part of the definition of the state. Now let us deal with Article 37. Article 37 of the Constitution, it states that the directive principles are not justiciable, that is, they are not actionable or enforceable. Courts in India cannot give directions and orders to the legislatures to implement the directives. Individuals, this means that, see, whenever we are saying that the directive principles are non-justiciable, it simply means that the courts in India cannot give directions to the legislature or executive to implement the directives. Individuals cannot go to the courts asking the court to initiate an order to the legislatures or the executive to implement the directive principles. Article 37 also states that it shall be the duty of the state to apply the principles in the making of the law. So the directives are bestowing a moral obligation on the state. It is a duty of the state or the government to apply the principles and the values mentioned in the directive principles while the making of the laws. So this is about Article 37 of the Constitution. Having discussed this, now let us read about what is the nature and characteristic of directive principles of state policy. What is the nature and characteristics? Nature and characteristics of directive principles of state policy. The directive principles of state policy represent collective rights. Collective rights of a just society, that is an egalitarian society. These are not individual rights, but a collective rights of a just and egalitarian society with equal social and economic opportunity. So you have to remember that welfare state fashions public policy to improve the overall welfare of its subject. That is, it is beyond a police state or an autocratic state where the state or the government is always seeking to improve the overall welfare and well-being of its subject. Indian state or the Indian government is a democratic state to implement the welfare of the people. The welfare of the people can be achieved by using the directive principles of state policy, which have a political obligation on the state. Political obligation. whichever political obligation on the government of the state. So directive principles have a political obligation, and also they have moral obligation on the Indian state. It can also be said that directive principles are called as the conscience of the constitution, as they contain the essence of Indian state's responsibility. They're a political obligation, moral obligation, and a conscience of the constitution, as they contain the essence of Indian state's responsibility. Directive principles of state policy contain positive ideas to guide governance in India, where successive state governments can take the help of directive principles of state policy to ensure that governance is for the well-being of the people. Governance is for the welfare of the people. Directive principles contain the principles so as to strengthen the welfare state and bring about an egalitarian society. So these are the nature and characteristics of the directive principles of state policy. Their collective rights, they have a political and moral obligation, they are the conscience of the constitution, okay, as they contain the essence of Indian state's responsibility. There are positive ideals for governance, and they seek to strengthen the principles of welfareism and egalitarianism. Having understood about these principles, the nature and characteristics of directive principles, now let us get into the details of Article 38. Article 38 of the Constitution says that state is to promote the welfare of the people by working for social, economic, and political justice. So state is to promote the welfare of the people by working for social, political, and economic justice. Number two, which was added by 44th Constitutional Amendment Act. This is called as Article 38B. It was added by 44th Constitutional Amendment Act in the year 1978. Okay, Article 38 Clause B. 38 Clause B. It states that state is to minimize inequality. State is to minimize inequalities in status, in facilities, in opportunities, and income between people and between groups in India. Number one is for the welfare, so as to ensure there is justice, socio-economic, political. Article 38 Clause B states about the state is to minimize inequalities in various dimensions between different people of India and different groups of India. So Article 38 represents the goals of the preamble of equality and justice. Equality and justice. It represents Gandhian ideology of trusteeship, which is a counter to Marx. Gandhian ideology. Gandhian ideology of trusteeship. Trusteeship, because it is seeking for justice and equality. So what Marx had said, Marxism speaks about the conflict between the capitalist and the labor, and the only resource to labor is labor, and if they multiply, there will be poverty leading to violent revolution against the capitalists. So Marx talks about a class conflict, wherein the means of production, who control the means of production, they determine the economic structure as well as the socio-economic political structure. So Gandhi says, in conflict with Marx, Gandhi doesn't talk about a class conflict or a violent revolution. Gandhi, he says that the rich people will hold their wealth as trustees of the people, and they will use this wealth for the welfare of the people. Once the rich people change their heart and undergo a transformation in the heart, they work for the welfare of the people and the poor, and there will be no class conflict. He also goes on to say that village should be self-sufficient and should not depend on the outside world for basic facility. This is called as Gandhi's Gram Swaraj ideology. Okay, by trusteeship, he means that people, the rich people are holding the wealth as trustees of the poor people, and the wealth will be utilized for the well-being of the poor people, and there is no need for a class conflict or a violent revolution. And Gandhi's Gram Swaraj scheme, Gram Swaraj idea, says that villages should be self-sufficient and they should not be dependent on the outside world. And there's another concept of Gandhi's Sarvodaya. By this we mean that the good of one lies in the good of all. Okay, the good of one lies in the good of all, or the good of all lies in the good of one. So it means that the good of all people ensures the good of an individual. That is, in the good of all lies the good of individuals. So if everybody in the society are in a good position, it will automatically ensure that the individual's well-being is also guaranteed. This is called as Sarvodaya. In the good of all lies the good of one. So that is about Article 38. Now let us discuss about Article 39 of the Constitution. Article 39 Clause A. Article 39 Clause A says that the state will ensure adequate means of livelihood to both women and men. Article 39 Clause B states that ownership and control of material or means of production should be. Article 39 Clause B is very important. We had mentioned about this article in our fundamental rights. Why? We will discuss in subsequent lecture. So, Article 39 Clause B says that the ownership and control of material resources should be such that it promotes social good. Okay, this is in relation to Gandhi's idea of Sarvodaya. So the means of production or the material resources of production should be utilized in such a way. The ownership and control should be such that it promotes social good. So when we discussed about fundamental rights, we discussed about Article 31 Clause C, which states that when Article 39B and Article 39 Clause C have been given precedence over fundamental rights under the 24th Constitutional Amendment Act of 1971, even if they are inconsistent with Article 14 and Article 19, because they are serving larger public good. Okay. Article 39 Clause C states that state is to prevent the concentration of wealth. Prevent concentration of wealth. State is to prevent concentration of wealth and the means of production which goes against the interest of the society. This is also promoting the idea of Sarvodaya. There shall not be concentration of wealth in limited hands. It should be distributed amongst different constituents of the society. Article 39 Clause D. This states that state will ensure equal pay for equal work for both men and women. Equal pay. Equal pay for equal work. For both men and women. Article 39 Clause E states that state is to promote the health of men, women, workers, and children. This also reflects about welfareism, about public health. So Article 39 is consisting of lot of important ideals of Gandhi, okay, liberal intellectual ideas. Okay. Then you have Article 39 Clause F. So it can be said that Article 39 constitutes a lot of ideals which support or which promote welfareism. Article 39 Clause F says that state is to promote the development of children in a healthy manner in conditions of dignity and freedom, and to protect children and youth from exploitation and moral violation or abandonment. Okay, so this is the various provisions in Article 39. So Article 39 is also talking about protection of children from exploitation and moral violation or abandonment. Okay, now let us discuss about Article 40. Article 40 is also a Gandhian ideal. Why? It says that state to organize village panchayats as units of local self-government. Okay, so Gandhi believed that the village should be a self-sustained or self-sustaining republic. Village should be a self-contained unit. This is the idea of Gandhian Gram Swaraj or village republic. Now discuss about Article 41. State is to create a social and economic system where work is available on demand. Work is available on demand. So the example of this article, the implementation of this article could be MGNREGA, that is Mahatma Gandhi National Rural Employment Guarantee Act, which is trying to create social and economic system where work is available on demand to the people. Also, Article 41, Clause B says that state is to create conditions for right to education. State to create conditions for right to education. Article 41, Clause C says that state is to provide assistance to old, aged, sick, and the disabled people. Article 41 thus has the ideals of a welfare state. It is talking about work on demand. It is talking about education. It is talking about assistance to the old age, sick, and disabled. So now let us discuss about Article 42. Article 42 says that state is to create humane conditions of work. Humane conditions of work. That is to preserve the dignity of the workers and to preserve the health of the workers. State is to promote maternity relief. This Article 42 contains the ideals of a welfare state. Again, it is talking about humane conditions of work, maternity relief, and other such welfare articles. Now let us discuss about Article 43. It says that state is to secure living wage for its workers. Living wage for its workers. State is to promote cottage industries. Cottage industries, and workers should enjoy a decent standard of living. Standard of living. State is to promote cottage industries, secure a living wage for workers, and workers to enjoy a decent standard of living and have leisure. Okay. Then you have Article 43, Clause A. Article 43, Clause A. This is an important article. Why? The workers are to be helped to become part of the management of industries and undertakings so that the productivity and responsibility of the workers at the workplace is improved and the workers become stakeholders of an undertaking. The industrial strife exists in India due to the conflict between the management and workers. And thus, this industrial strife can be lessened and harmony can be created by the implementation of Article 43A. It is a socialist idea. Okay, and this was introduced by the 42nd Constitutional Amendment Act of 1976. Okay, this Article 43A was included by 42nd Constitutional Amendment Act of 1976. Now let us discuss about Article 44. Article 44 talks about Uniform Civil Code. The state is to secure a uniform civil code for all the citizens throughout the territory of India. This is a liberal intellectual idea. We will discuss about Article 44 in just let us take a pause for 1 minute. So what does Article 44 deal with? It deals with Uniform Civil Code. So this Article 44 talks about the state to secure a uniform civil code for all the citizens throughout the territory of India. You know that India is a multi-religious society. Okay. So a multi-religious society where every religion has its own personal law, which deals with secular activities of a person, like the earthly aspects or the worldly aspects that a person has to deal with in day-to-day life, like marriage, divorce, okay, the process of religious practices, and likewise. So a uniform civil code was envisaged by the founding fathers because personal laws have always discriminated women against. So, in most of the personal laws, there is discrimination against women and children. Okay. So, for example, before the Hindu Marriage Act of 1956, so before the Hindu Marriage Act of 1956, sorry, Hindus were allowed to take more than, they were allowed to marry more than one wife. Also, the Christian Marriage and Divorce Act of 2010. Before the 2010, getting divorced was nearly impossible for a Christian woman. She had to prove matrimonial offense of cruelty and polygamy by Bible. Okay, by by the Christian Marriage Act and Divorce Act 2010, Christian women can get divorced by proving bigamy. So, what is this Uniform Civil Code? The state is to pass laws that apply uniformly to all the citizens of India. That is, personally, legally, and officially, all the people of India are obligated to follow one uniform civil code and follow uniform laws so that the secular as well as religious activities will not be in conflict with each other. The uniform civil code will lead to gender justice in India. It will strengthen the rule of law in India, and therefore it will strengthen equality before law, and it will also lead to national integration. Gender justice, rule of law, equality before law, and national integration. So this Hindu Marriage Act 1956 states that it sought to make the personal laws more rational. That is, Hindu Marriage Act, Special Marriage Act. A Hindu convert to other religion can inherit property in accordance to Hindu personal law. So it can be said that Goa is more or less one state in India presently which has a uniform civil code even without passing a uniform civil code. So most of them most of the people, citizens of Goa, agree on the principles of Portuguese civil codes. Okay. That is about Article 44 regarding Uniform Civil Code, which will guarantee gender justice, rule of law, principles of natural justice, and also equality before law, and national integration. Now let us deal with Article 45. The 86th Constitutional Amendment Act of 2002. The 86th Constitutional Amendment Act 2002 had made some amendments to Article 45. Earlier, it said that state is to provide within 10 years of the commencement of the Constitution education to all children below the age of 14 years. So, based on this, Article 21 of A of the Constitution, Article 21 of the Constitution made education as a fundamental right. Education between the age of 6 to 14 years as a fundamental right. So now this Article 45 says that state to provide early childhood care and education to all the children below the age of 6 years. State to provide early childhood care and education to all the children below the age of 6 years. Okay, so this is about Article 45 of the Constitution. Because when Article 21A made fundamental right to education as a fundamental right for all the children between 6 to 14 years, there was change in this Article 45 after the 86th Constitutional Amendment Act, and it sought to provide The state is to provide early childhood care and education to all the children before 6 years. Then Article 46 calls upon the state to promote educational and economic interests of SC, STs and other weaker sections of the society. Educational and economic interests. Both the educational and economic interests of scheduled castes and scheduled tribes and other weaker sections of the society should be taken care by the state, is what this article is talking about. Now let us discuss about Article 47. It is also a Gandhian directive. It says that state is to raise the standard of living of the people. State is to take steps to raise the level of nutrition of the people. For example, the National Food Security Act, implemented by the government of India, is seeking to raise the level of nutrition of the people. The standard of living of the people is sought to be improved through the MGNREGA. State is to improve public health. You have the National Rural Livelihood Mission, National Health Mission. And also, state is to prohibit the consumption of drugs and alcoholic or intoxicating drinks, except for medicinal purposes. So, for example, Gujarat, the state of Gujarat has been under prohibition since the times of independence. So this Article 47 talks about standard of living, nutrition of people, public health, and prohibiting of alcoholic and intoxicating drinks. And it is more or less a Gandhian directive. Then let us discuss about Article 48. This is also a Gandhian directive which talks about state to organize agriculture and animal husbandry on modern scientific lines. Number 2, state is to prohibit the slaughter of cows, cattle, and all milk-giving or draught animals that is used for farm work. So it talks about agricultural improvement on modern scientific lines. It is talking about prohibition of animal slaughter or cow slaughter and cattle and all milk-giving draught animals. And then it is talking about state to improve the breed of cattle and other livestock. So that is about Article 48 of the Constitution. Then we have Article 48, Clause A. This talks about state to protect and preserve wildlife, forests, and environment. So this has been included in the Constitution by the 42nd Constitutional Amendment Act of 1976. So this is in line with the principles of Sustainable Development Goals and Millennium Development Goals. Okay, the state is to protect and preserve its wildlife, forests, and environment so as to evolve sustainable models of development. Now let us look into Article 49. It talks about state to protect all the monuments of national importance, historical importance, and cultural and artistic importance. It talks about protection of Indian heritage and culture. Okay. For example, Taj Mahal has to be protected because it is a national monument. It has historical and cultural and artistic significance. The Archaeological Survey of India has also the duty to protect this heritage of India. Then you have Article 51. It talks about Nehru's idea of Panchsheel. This is somewhat related to international affairs for the peaceful coexistence of states, peaceful coexistence of various countries. The Indian state is to promote international peace and security, to work for honorable relations between nations, and to encourage respect for international law, and to encourage settlement of international disputes peacefully. Okay, it is talking about international peace, honorable relations between nations, encourage respect for international law, and also to settle disputes amicably and peacefully. Sorry, I forgot about Article 50. We'll discuss about Article 50 now. Article 50 is about rule of law. It talks about state to separate judiciary and executive as organs of government. There shall not be encroachment between different organs of the government. It is part of the rule of law because Dicey, AB Dicey, says that if government power is concentrated in one authority or one organ of government, it will automatically lead to authoritarian regime as there is no check on arbitrary governance. The lack of arbitrariness in governance can be brought about by separation of powers between the organs of the state so that each organ acts as a check on the other and prevents overstepping of the jurisdiction of the authority. So, Article 50 talks about separation of powers between the legislature and the executive organs of the government. You know that the constitutional scheme talks about separation of powers between legislature, executive, and the judiciary. So that is about the directive principles of state policy. Now let us have a glimpse at the directive principles of state policy, which were added through various constitutional amendments act. Various constitutional amendment acts have added several directive principles of state policy, which we will discuss now. We have already discussed, but we will discuss again in elaborate manner. By the 42nd Constitutional Amendment Act of 1976, the directive principle of Article 39 Clause F was added, which talks about state to create conditions for children to develop in a healthy manner with dignity and protection against exploitation. Then you have Article 39 Clause A. The state is to provide free legal aid. Free legal aid free legal aid to the poor and to develop a judicial system and reform it, which works for equality of justice to all people and equality of opportunity to access judicial system. That is about Article 39, Clause A. Then you have Article 43, Clause A. It talks about state to encourage the participation of workers in the management of industries and companies as stakeholders so as to provide for industrial harmony and productivity of workers at workplace. So 42nd Amendment Act added Article 39 clause F, Article 38 clause, Article 39 clause A, Article 39 clause F, and Article 43 clause A, and also Article 48A, which we already discussed a while ago. State is to promote, protect, preserve, and conserve forests, wildlife, and environment. This calls for sustainable development. If more wealth is created by the state by economic development, the state can carry out its welfare activities by accelerating growth rate, but this will lead to intense exploitation of resources, leading to environmental and ecological problems. This leads to a threat to the development of the economy due to the extinguishing of natural resources, and it will possibly lead to adverse impacts of climate change and lead to overall degradation of the ecosystems. This economic development should take place at a rate where the natural resources can regenerate themselves in a manner which is sustainable. Then we have 44th Constitutional Amendment Act of 1978. So it provides for Article 38, Clause B. State is to minimize inequalities. State is to minimize inequalities in income, status, and opportunities and facilities. So Article 39 Clause B talks about state to minimize the inequalities in income, status, opportunities, and facilities. Then you have, by the 86th Constitutional Amendment Act 2002, this changed the directive in Article 45. It talks about state will provide early childhood care and also promote free and compulsory education till the age of 6 years. So these are the directives added by various constitutional amendment acts. Then you have some special directives. Special directives are the directives that are not contained in Part 4 of the Constitution. You have Article 335. It talks about state to take into account the claims of SCs and STs in making appointments to various posts in the Government of India and state services, while also maintaining efficiency in administration. State to take into account the claims of scheduled castes and scheduled tribes in making appointments in various posts, while also maintaining efficiency in the administration. Then you have Article 350. Article 350 talks about every citizen should be given an opportunity to present his grievance for its solution to the state in any of the languages used in the union or the states. As India is a multilingual society, this provision was provided. Then you have Article 350 Clause A. It talks about every state and every local authority under the state is to take steps so that the children of linguistic minorities are able to get primary education in their mother tongue, and the President of India can issue directives to the state to enforce the same. Then you have Article 350 Clause B. It talks about the President of India has to appoint a special officer for linguistic minorities who will look into the implementation of the various safeguards provided for the linguistic minorities. The chairman has to submit the report to the President of India. The President of India will table the report of the Special Officer of the Linguistic Minorities in both the houses of the Parliament. So, Article 350 Clause B talks about Special Officer for Linguistic Minorities to be appointed by the President of India. Then you have Article 351. This is an idea of Nehru. The state is to promote the use of Hindi as a common language throughout the territory of India, and also to develop Hindi as a link language between the union government and the state governments. So this is about promotion of Hindi. Article 350, 350A, 350B talks about language and linguistic minorities. 351 talks about Hindi. Article 350 talks about again language. Article 335 talks about SC/ST's appointment and maintaining efficiency in the administration. So this is about the this is about the directive principles of state policy. In our next video, we will discuss about the fundamental duties.